One of my constituents, Christina Garcia, was able to obtain insurance coverage and have surgery that saved her eyesight only before the Affordable Care Act. Her experience is not unique. Senator Tammy Baldwin has a constituent, Jimmy Anderson, in her home state of Wisconsin, and she asked that this story be shared. Jimmy is a 34-year-old and member of the Wisconsin State Legislature. In 2010, a drunk driver hit the family's car as they were returning home from celebrating Jimmy's 24th birthday. Jimmy's mother, father, and little brother were killed in the accident. Jimmy was paralyzed from the waist down. His medical recovery was intense. As Jimmy has said, quote, "Doctors managed to patch me up with dozens of stitches and multiple surgeries and about a pound of steel on my spine," end quote. But soon after, his insurance company told him he was nearing his lifetime maximums and he would have to pay for the rest of his health care expenses. As Jimmy explains, quote, "With hundreds of thousands of dollars still left to go, I don't know what I was going to do. I was scared. I was terrified. I was just a student. I didn't have that kind of money." Fortunately, a few days later, the insurance company sent him another letter. This one informed him that the provisions of the ACA had kicked in, which meant there were no longer lifetime maximums and his care would be covered. In Jimmy's own words, "I was able to put my life back together, and I credit the Affordable Care Act for that." Judge Barrett, how should the loss of ACA's protection against lifetime coverage caps that can be used to end coverage for life-saving care, factor into a court's consideration of the validity of the ACA?
Senator, so far as I know, the case next week doesn't present that issue. It's not a challenge to pre-existing conditions coverage or to the lifetime maximum, relief from a cap.
Well, what is your view
of how it should factor in? Let's see. I think that any issue that would arise under the Affordable Care Act or any other statute should be determined by the law, by looking at the text of the statute, by looking at precedent, the same way that it would for anyone. And if there were policy differences or policy consequences, those are for this body. For the court, it's really a question of adhering to the law and going where the law leads and leaving the policy decisions up to you.
For me, my vote depends a lot on these responses because these are life or death questions for people. It's my understanding that you were critical of Justice Roberts for upholding the ACA, stating that he, quote, pushed the Affordable Care Act beyond its plausible meaning to save the statute, end quote. And in what way did the Chief Justice go beyond the ACA's plausible meaning?
So I've written about this, and that description is consistent with the way the Chief Justice described in his own majority. That was King versus Burwell, where the court had to decide whether the phrase established by a state also included exchanges that were established by the federal government. And the majority in that case acknowledged that treating the phrase established by a state as including exchanges established by the federal government was not the most natural reading, but for other reasons, other policy reasons and canons of interpretation, they chose to adopt the less natural reading.
You see, for me, the case coming up, California v. Texas, puts a whole new weight on your nomination. Because the Affordable Care Act is now being so well accepted. I represent the largest state, as does Senator Harris, that we have. And there are just over 10 million people dependent on the activities under this act and that they be sustained. And so there is really great concern about what your view is. That case is coming up. Can you give us at least your view?
Well, Senator, the issue in the case that's coming up doesn't involve, it's not the same issue as the ones in NFIB versus Sebelius or King versus Burwell. It's a different issue.
Well, then give us both.
Well, let's see. So what I said, what you quoted to me, was that I thought that the interpretation of the phrase established by a state was stretched when the court held that it was established by the federal government. That's not the issue in California versus Texas. The issue in California versus Texas is if whether now that Congress has just completely, zeroed out the mandate, whether it's still a tax or a penalty, and even if so, is it constitutional? And then even so, is that fatal to the statute? There's a doctrine called severability, which sounds like legalese, but what it means is it okay with the statute? Could you just pluck that part out and let the rest of the statute stand? Or is that provision which has been zeroed out so critical to the statute that the whole statute falls? So really the issue in the case is this doctrine of severability, and that's not something that I've ever talked about with respect to the Affordable Care Act. Honestly, I haven't written anything about severability that I know of at all.
So you have no thoughts on the subject?
Well, it's a case that's on the court's docket, and the canons of judicial conduct, would prohibit me from expressing a view.
Okay, I'll move on. On July 30th, 2020, President Trump made claims of voter fraud and suggested he wanted to delay the upcoming election. Does the Constitution give the President of the United States the authority to unilaterally delay a general election under any circumstances? Does federal law?
Well, Senator, if that question ever came before me, I would need to hear arguments from the litigants and read briefs and consult with my law clerks and talk to my colleagues and go through the opinion writing process. So, if I give off-the-cuff answers, then I would be basically a legal pundit. And I don't think we want judges to be legal pundits. I think we want judges to approach cases thoughtfully and with an open mind.